What's up everyone, it's the Law School Lumberjack here again with another video. Today we're doing another installment of our Corporations Law 101 or Business Organizations Law 101 series. In our previous video we touched on sole proprietorships and general partnerships. Now both of those business relationships involve something called unlimited liability. And what that essentially means is the sole proprietor, if it's a sole proprietorship, or the general partners, if it's a general partnership, we're all responsible for the debts and liabilities of their respective business entities. So as a business owner, this is not very good. So you might be wondering, is there a better way? And the answer is there is, which is what our video will be about today. Today, we will be looking at limited partnerships and limited liability partnerships, with a focus more towards the limited partnerships because they're the more common things that are talked about in most of your law school classes. As I said in my previous video, which I'll link down below, on general partnerships, partnerships are not talked about in great detail in your corporations law course. So this video will be meant to be just a brief primer on what limited liability partnerships and limited partnerships are. So without further ado, let's get started with a limited partnership. So with a general partnership, all partners work presumptively equal. With a limited partnership, what you have is a different structure. So you have a general partner who's running the management of the company and is running the day-to-day, and then you have what are called limited partners. The general partner in a limited partnership faces unlimited liability. They are responsible and liable for the debts and liabilities of the partnership. However, the limited partners face limited liability. And what that means is that their liability is capped at what they've invested in the partnership. So to make this clear, let's use an example. Let's give an example of a limited partnership between two parties. You have partner A, who's the general partner, and partner B, who's the limited partner. Now, partner A invests $1,000, and partner B, the limited partner, also invests $1,000. Let's say, as in my previous video, they're running a lemonade stand, and partner A accidentally gives bacteria-laden water to his customers. The customers get sick and sue the limited partnership for $1 million. Because the limited partner is only liable up to his initial capital contribution, being $1,000, the parties can go after the limited partner for his $1,000 share, but the remaining $999,000 of liability will be borne by the general partner as a result of his unlimited liability. But this does come with a catch. The limited partner only faces limited liability so long as he does not get involved in the day-to-day management and operation of the partnership. And so if the limited partner starts overstepping his bounds, working day-to-day in the partnership, then he may lose his preferential status as a limited partner and be treated as a general partner. There's two main factors that are looked at when the limited liability of a limited partner is challenged as a result of them being involved in the day-to-day management of the partnership. The first is how the limited partner held themselves out to the rest of the world. So using that lemonade stand example, if the limited partner is day-to-day at the lemonade stand selling lemonade to parties, it's very unlikely that he will be seen as this passive investor in this limited partnership. The other more nuanced factor that is looked at is how the decisions of the limited partner are handled by the general partner. And my understanding of that is that if the general partner is essentially being used as a puppet for the limited partner, then even though the limited partner is not the face of the company, it's more likely that the limited partner is engaged in the day-to-day management of the company. So let's say if, for example, the limited partner is telling the general partner how to run the day-to-day management, and this general partner is just basically a marionette or a puppet doing what he's told, then it's more likely that the limited partner will in fact be treated as part of the day-to-day management and a general partner facing unlimited liability. Now compare this to a situation where the general partner has final say and the limited partner can maybe give suggestions or ideas, but the general partner has the right to veto those. If the general partner in all these decisions has the right to say no, and clearly does say no, it's less likely that the limited partner will lose his preferential treatment and the limited liability associated therewith. Now, the final aspect that I want to touch on very briefly with a limited partnership is in the last video with the general partnership, I talked at decent length about how a general partnership you can either do by agreement or in a formal manner, or sometimes that a general partnership can be formed unintentionally through statute and common law if people are working together with a view to profit. So with a limited partnership, in most jurisdictions, you can't have that situation where you're deemed to be limited partners. The limited partnership is a formalistic structure that's created to have preferential treatments to certain parties and certain partners. So as a result, that requires registration of the limited partnership at your corporate registry. Depending on what province you're in, there will be different requirements, but generally it involves some form of partnership agreement, a declaration, and several documents that must be filed. So unlike with a general partnership where it can be created on an ad hoc basis and unintentionally, a limited partnership is much more formalistic and cannot be created by accident. Now we come to a limited liability partnership. So what a limited liability partnership is, it's essentially a formal partnership relationship among different parties which is engaged in the practice of providing services of a certain profession. So, and those professions are oftentimes prescribed in your provincial partnership legislation. So some examples of professions that can avail themselves of the limited liability partnership are accountants, lawyers, doctors, engineers, etc. What the limited liability partnership really is in operation is it's a bit of a hybrid between the limited partnership and the general partnership. With the limited liability partnership, all partners are jointly and severally liable for certain expenses and obligations of the limited liability partnership, including but not limited to the unremitted taxes associated with that limited liability partnership and the payment of the employee's wages. However, the limited liability partnership, unlike the general partnership and more like the limited partnership, does offer some protection to limit the liability of each of the partners. Let's say a limited liability partnership exists between partner A, partner B, and partner C. The benefit of the limited liability partnership is that if partner A acts in a negligent fashion or does something which incurs liability on the limited liability partnership, as long as partner B and partner C weren't involved in that negligent act and didn't know about that negligent act and do nothing to stop it, then partner B and partner C are not responsible for the actions of partner A. In other words, in a limited liability partnership, the partners who are innocent are protected from the negligent acts of the other party. Now, similar to the limited partnership, the limited liability partnership is a formalistic business relationship and involved in most provinces, if not all, the registration of certain documents in your provincial corporate registry. As a result, the limited liability partnership cannot be created by accident, unlike the general partnership. So you generally cannot have a situation where the limited liability partnership is deemed to exist like it can with a general partnership. So again, the purpose of this video was not to do a deep dive into limited partnerships or limited liability partnerships, but rather the purpose was to give an overview of some of the key characteristics of the limited partnership and the limited liability partnership, namely to show how compared to a general partnership, these business relationships have additional protections in the form of limited liability. Now, in subsequent videos, we will be doing a much deeper dive into corporations, which have the most protections for shareholders who are seeking to have true limited liability. In any event, I hope this video was helpful. If it was, I'd really appreciate it if you could like and subscribe. Thank you very much. Take care. Have a good evening.